Government overreach has gotten ridiculous, and it doesn't take a creative imagination to see the Department of Transportation forcing us to have some Big Brother hall monitor right along in our car watching us drive. But there are two cases in front of the United States Supreme Court that could help cut back on the insane government overreach that has gotten out of control over the last few decades. The first case is Relentless versus Department of Commerce. The Relentless fishes for herring off the New England coast, and the federal government regulates commercial fishing because the federal government likes to regulate everything. And in their infinite wisdom, the weather people at NOAA, who for some reason regulate commercial fishing, create a rule that requires commercial fishing vessels to carry federal monitors aboard the vessels when they're out fishing. So the Relentless is required to carry fish cops on their ship and pay the salaries of those fish cops when they're out going fishing for herring. The cost the Relentless has to pay to have these fish cops aboard can sometimes exceed the profit that they make fishing for herring, which makes the whole process commercially untenable. So the Relentless, true to her name, is suing the government. Now, I'm not a maritime lawyer, but I certainly do appreciate a good story of the little guy fighting back against the giant government. But how did such a ridiculous rule come about in the first place? It all started back in 1984 when Americans were falling in love with some of the greatest movies ever made. And I don't care what they say, there are only 3 Indiana Jones movies. The Supreme Court heard the case of Chevron versus National Resources Defense Council. The core issue in that case was how to interpret the word source in the Clean Air Act. For example, if an oil refinery wanted to expand, the EPA was supposed to determine if there were any new sources of air pollution and regulate accordingly. Originally, the EPA interpreted source to mean anything new, whether that was a whole new factory, a new boiler, or just a new smokestack. But then President Reagan came along trying to shrink government and deregulate. Reagan's EPA said, "That's stupid. We're going to interpret source to mean an entire factory or building. We're not going to focus on each individual boiler or smokestack." The NRDC wasn't happy about that and sued. The oil giant Chevron fought back. In the end, the Supreme Court decided if the law empowering an administrative agency is ambiguous and that agency comes up with a reasonable interpretation of the law, the courts will let that interpretation stand. Which is all fancy lawyer talk that means if a congressional law is ambiguous, the administrative agency in charge of implementing the law gets to decide what it means. And thus, Chevron deference was born. Ironically, at the time, that was considered a win against government regulation because Reagan's EPA was trying to interpret the Clean Air Act to impose less regulations on pollution sources. So is Chevron deference really all that bad? We learned in school that bills become laws by Congress deliberating, voting, and then the president signing them into law. It's a great system. We, the people, vote based on who we want to represent us, our beliefs, and our values. Those people deliberate and pass laws based on what we think should happen. But the vast majority of our federal laws and regulations are not passed by our representatives who represent us. They are created by bureaucrats hiding within executive branch agencies. What some people call administrative law, I just call garbage. And even when a good president like Reagan comes along and tries to deregulate things, the overall breadth and scope of administrative law seems to do nothing but expand. In 2021, Congress passed 81 new laws. Guess how many federal administrative regulations were enacted in that same year? 3,257. Some people might say, but Congress doesn't have time to pass all those rules themselves. To that I say, good. Fewer federal rules is better for everyone. That's how the founders set up this republic. The states get to regulate most things, and the federal government should only be regulating and penalizing things that they have to do on a federal level. Most things do not need to be taken care of in Washington, D.C. What also grinds my gears is that Chevron deference is the exact opposite of how the criminal justice system works when something is ambiguous. In America, you are innocent until proven guilty. And when a criminal law is ambiguous, we construe the law against the government and in favor of the little guy, aka the defendant. The fancy lawyer term for this is the rule of lenity. A famous example goes back to 1820 when there was a killing aboard a United States merchant ship on a half-mile wide portion of the Tigris River in China. The Supreme Court had to interpret a federal statute that criminalized manslaughter on the high seas. Was it manslaughter? Definitely. Did it take place on the high seas? Not really. Because the term high seas was ambiguous, the court ruled against the government and in favor of the defendant. But Chevron deference is the opposite of this standard. When the weather people at NOAA want to put fish cops aboard the Relentless, the standard is, well, it's ambiguous, so we'll let the government do what they want. But the Supreme Court might be about to correct that. Relentless versus Department of Commerce and Loper Bright Enterprises versus Raimondo are encouraging the Supreme Court to reconsider and potentially overrule Chevron deference. If the Supreme Court leaves Chevron deference in place, this will only lead to even more regulation in all of our lives. Whether you own a business or you're just a private person, the government's coming to regulate more. Because if NOAA can force fishermen to pay the salaries of fish cops, what's stopping the Department of Transportation from forcing you to pay for a cop to ride around in your car? What's stopping them from forcing you to have different safety features and equipment in your car that you already do? But if the Supreme Court overturns Chevron deference, it would be an important change that would stop administrative agencies from simply imposing their will upon us when congressional empowering legislation is not clear. Hopefully, the Relentless will succeed in cutting down the mightiest tree in the forest with a herring.
We shall do no such thing. Oh, please.
And if it's not the weather people harassing you, it could be the gun police. What if the cops show up at your door demanding to see your guns? What should you do? Check out this next video where I explain exactly what you should do to defend yourself. And as always, don't talk to the police, especially the fish cops.